Hi, I'm James Minick, and today we're going to talk about the defense of duress or coercion in the context of a DWI case. This is an affirmative defense to a charge of driving while impaired, and one that needs to be proved by the defendant to the satisfaction of the jury. This is a defense that would typically come up in a situation where there is an assault allegation or basically an assailant where the defendant basically is in fear of being harmed and that is what causes the actions of driving. To establish the defense of duress, a defendant must prove to the satisfaction of the jury that his actions were caused by a reasonable fear that he or another would suffer immediate death or serious bodily injury if he did not commit the crime. The focal point of establishing the duress defense is the reasonable fear that the defendant or another person would suffer bodily injury. The difference between this defense and the defense of necessity is, I think, very important. I think there is a broader context of cases or factual situations where you might be able to argue the necessity defense. I think that the duress defense is somewhat limited to kind of assault type situations or basically a very violent situation. The necessity defense, I think, could actually apply to a broader context of cases. We've done another video and blog on the necessity defense. But the value, I think, of the duress defense in the context of a DWI situation is that, unlike the necessity defense, the duress defense does not require that you show to the judge or jury that driving was the only available alternative. Basically, all you have to show, the defense is based around that there was a reasonable fear that the defendant would suffer immediate death or serious bodily injury if he did not commit the crime. So it doesn't matter if there's other available options to the defendant in terms of not driving. It's I drove because of a reasonable fear that myself or another would suffer immediate death or serious bodily injury. So I think that in the assault context, it very well may be that the duress defense could be proved, where the necessity defense, if argued in the same under the same circumstances, and there's nothing that prevents you from arguing both defenses, but that the defense of necessity may not be appropriate because there might be other available alternatives that are reasonable alternatives. There's no requirement that there be other that there not be other reasonable alternatives in terms of being able to establish the defense of duress. The courts have looked at in several situations, and they've kind of discussed this both in the context of necessity as well as duress, but the courts have looked at several situations where the defense of duress dissipates. In State versus Cook, evidence tending to show a defendant's appropriate flight from the pedestrian pursuers does not continue 30 minutes after his pursuers have been left many miles behind. So the court found there was evidence of duress in that particular situation, but it doesn't continue indefinitely. Once a person has put themselves out of harm's way, the justification for driving basically ends. This would be a situation where notice of the defense would be required to be given upon request from the state. In a situation where the DWI charge is a felony. For misdemeanor cases, typically discovery statutes do not generally apply, and so it might not be required to give notice of the duress defense on a misdemeanor DWI that's been appealed up to Superior Court. But on a felony habitual DWI or DWI that occurs with a serious bodily injury that results in a felony death or a felony injury charge, that might require the defense to give notice of the defense of necessity under 15A-905C1. There is also a pattern jury instruction for duress. That is in our blog materials, so please go there for a copy of the pattern jury instruction for duress, and we've kind of tried to tailor that as well to looking at this in the context of a DWI charge. So that's what we have on duress. Again, we have a blog on necessity and a article, a video on necessity as well. You may be able to argue both, but certainly the duress defense is available potentially in a situation where your client has been assaulted, and that is what caused the driving.